Morning, Madam Deputy Registrar. Kindly call the matter.
Thank you, Judge. Good morning. Caribbean Court of Justice, Appellate Jurisdiction, an appeal from the Court of Appeal of Belize, hearing of appeal in CCJ Appeal BZCV number 1 of 2025 between Beth Clifford, Beltway Investment Group Incorporated, and LCW Investments Limited Liability Company. The members of this morning's panel are Madam Justice Rajnath Lee, presiding judge.
Good morning, everyone.
Mr. Justice Barrow.
Greetings to all.
Mr. Justice Jamada.
And good morning to everyone.
Madam Justice Ononewu.
Good morning, everyone.
And Mr. Justice Ebo Osuji.
Good morning, all.
May we have the appearances, please? Thank you.
May it please your honors. Eamon Courtney, appearing for the appellants. With me is Ms. Priscilla Banner, senior counsel. Appearing for the respondent are my learned friends, Mr. Andrew Marshalek, senior counsel, and Mr. Gerard Isugiri.
Thank you very much, Mr. Courtney, and good morning again to counsel, Mr. Courtney, Mr. Marshalek, and to your teams. We are ready to have to listen to your submissions this morning. Mr. Courtney, Mr. Marshalek, I take it you're all ready to go.
We are indeed.
Yes. Thank you very much,
Yes,
Mr. Courtney. I believe you may start.
Obliged. Your honors, this appeal arises from the decision of the Court of Appeal, which found that Ms. Beth Clifford, and Beltway Investments Limited are liable for damages arising from a breach of contract by Green Development Partners, who I will refer to as GDP during my submissions. The appellants say that the Court of Appeal was wrong to so find. The court will be aware that the basis for the finding of liability for Ms. Clifford was that the corporate veil of GDP was supposedly pierced and liability was imposed on her. Insofar as Beltway is concerned, it is my understanding from the trial judges, from the Court of Appeals judgment, that Beltway received the money and no evidence has been given as to what happened to the money, and therefore it is called upon to make good, to pay back LCW, the respondent. Your honors, we say these findings are wrong and unsupported by evidence and the law. Could I first take you to, to state the obvious. Green Development was found in breach of contract. It appealed, it lost on appeal, and it has accepted the decision of the lower courts. So in my respectful submission, the question of breach no longer arises and need not detain the court at all. We have submitted very specifically that there is, on this appeal in our submission, no re-litigation or examination as to whether or not Green Development GDP was liable in breach of contract. Your honors, perhaps the most appropriate place for me to start is to take a look at the agreements, which can be found at the record at page 227. Whilst the court is going there, I will say up front that the agreement, what is called an order form, and attached to it is a lot purchase and house construction order form, are, to put it mildly, very unusual, very strange documents insofar as lawyers practicing in the Commonwealth Caribbean are concerned. But nevertheless, these are the documents upon which the parties struck their bargain, and this is the agreement that Green Development was found to have breached. So very quickly, if the court is at page 227, this is the lot purchase and home construction summary, and it shows that the respondent is the buyer of the property to be bought. The purchase price is $780,900 United States dollars, and it says how it is to be paid. The total deposit is $78,090. The land company, Corporate Investment Holdings Limited, is named in the agreement, but it is not a party to the agreement. And secondly, the land, lot 259, owned by 5801 GOA 2105 Inc., an Anguillan company, is the owner of the land in question, namely lot 259. There is a separation of the purchase price. The land price is $135,000. No deposit was made on the land, and a house construction company, Green Development Partners Limited. What was to be built was a keeping suite, and August 1st was set, 2017 was set as the funding day for total balance. $645,000 was for the house. And the deposit is there, and the construction start date is next available. Your Honors, I say that it is indeed strange for this document to be relied upon by Green Development and Ms. Clifford and Beltway, where, as you can see straight off, Beltway appears nowhere on the document, and the land company, Corporate Investment, the owner of the land, are not parties to the summary. At page 228, and I just pause to say that at the bottom of page 227, you will see the initials of the parties. At page 228 to 229 is what is called the lot purchase and house construction order form. I won't take the court through it. Suffice it to say, this is the document on which, as I say, the bargain was struck, and it was that Green Development was to build this keeping suite, and when it was finished, that the land was to be transferred to LCW, the respondent. One issue, and I will return to it later on, that arises is that the witness for LCW, Mr. Williams, says that it was not made clear to him, or let me put it differently, he understood that he was going to get title, i.e. a certificate of title, as opposed to what the Green Development and Ms. Clifford understood, that they would transfer the shares in the Anguillan company, which owned the land, in effect giving him title. Other than that, Your Honors, this is the bargain. House will be built by Green Development. The purchase price was paid. At the conclusion of it, after the house was built, the keeping suite, the shares in the Anguillan company would have been transferred to LCW, and as far as Green Development and the other parties are concerned, they would have delivered their end of the bargain. It cannot be denied that there was gross delay. There was inexcusable delay. Myriads of explanations and excuses were given as to why there was no completion of the house or the keeping suite and the transfer of the land. That matter has been settled by the courts below, and I will not, as I don't think it arises, seek to justify at all the failure of Green Development to deliver within a reasonable time. Again, in passing, you will see that the construction start date on the summary says next available. In his evidence, Mr. Williams says he was actually told by someone a specific start date. Again, that does not, in my respectful submission, auto detain the court simply because they failed to deliver within a reasonable time. Now, Your Honors, I leave that and say the following. We submit that the framework, the approach that we would invite the court to take when assessing this appeal is to do what we say, and it is this: but for the delay, there would be no case. I repeat, but for the delay, there would be no case. What do I mean? I will take the court as quickly as I can through the evidence to show that if there was no delay, LCW, represented by its witness, Mr. Williams, wished to have the lot 259, wished to have the keeping suite, and in fact gave extensions, understood that there were delays, and reached a point where he said, no more, give me back my money. The evidence will show in our respectful submission that Mr. Williams fully understood the two documents that I just referred to. Mr. Williams was never misled by any of those documents. Mr. Williams was not ever saying, did not ever say that he misunderstood the documents. All of those arguments, fraud, confusion, misled, are legal arguments divorced from the evidence of the respondent. Your Honors, I would like to very quickly take the court through the witness evidence of Mr. Williams. I will not go through his witness statement, his evidence in chief. I will leave that to the court. All I will say is you will read that from beginning to end, and you will find Mr. Williams nowhere complaining that he didn't understand what he was involved in, that he didn't understand these documents, that they were confusing, that fraud was perpetrated on him. There is no to take you to cross-examination and to highlight a number
Mr.
of
Courtney,
pages in the record.
if I may,
Yeah.
As I understand your submissions, especially your reply submissions, your client's position is that everything that Mr. Williams contracted for, although greatly belated, is there for him to get. So there's lot 259, it exists. The building to be constructed on it exists. And therefore, Mr. Williams, but for the fact that there was this gross delay, what you contracted to get, you can get. Is that correct?
Correct, Your Honor. And I was going to take you in this look at the cross-examination where he accepts that that is so, but that he says essentially it's too late, I've moved on. And in fact, he accepts. They attempted to offer it to him and say, well, if you don't want it, let us agree to sell it. And he says, no, I don't want to participate in that. I want back my money.
Yeah, so Mr. Courtney, you were, for the rest of us, you were directing us to those pages?
Yes.
Yes.
Yeah. Page
Yes,
1411 of the record.
1411? Mm-hmm.
Yes, and this is a cross-examination of Mr. Williams.
Mm-hmm.
At page 1411, at line 10, he's asked the question, and you read and understood the order form and summary page when you got it? Well, let me ask you first, did you read it? Yes. You read it and you understood what it said? Yes. Yes. No. would you agree with me, Mr. Williams, that this summary page provides sort of a concise view of the entities that would be involved in relation to the land transaction on the one hand and the house construction on the other hand? Correct. Over page. And you will see there that on that page, first page, the land price is 135,000, correct? Yes. You are aware that 150,000 was eventually paid for the land? I was, because the price went up. It was 2 years later, so the price had gone up. So the first point, he fully understood the order form. And I should just say to the court, in his evidence in chief, he says he's a man of, I believe, in excess of 25 years experience as a realtor. At page 1437,
$14.37.
1437, Your
Yes,
Honor.
thank you, Mr. Courtney.
At the very top, now, Mr. Williams, show me where on this summary page at page 240, can you see the name Beth Clifford? It is not. I'm sorry, 248. 248, the summary page. Beth Clifford's name isn't on any of these documents. We can agree on this. He was not contracting with Beth Clifford. Can I take you next to page 1441?
$1441, Mr. Courtney. Thank you.
1441.
Yes, thank you.
At line 6, question. And you agree that you read and signed this agreement when you saw that? Yes? Yes, absolutely. Now, with respect to the land company is Corporate Investment Holdings Limited, correct? That is what it says on the order form, yes. You are talking about the summary. That's what the summary says. You agree? Correct. Also, the summary points out that the company, Block 259, is owned by 5801 GOA 2105 Incorporated. Correct. Correct. And so when you read the summary, you appreciated that the land was held in the name of that incorporated company of Anguilla. Correct? Yes. Yes. And then on the next page, and in fact, Mr. Williams, it was explained to you that the shares in the company will be transferred to you so that you will fully own the company, which sole asset was the land. Correct? That is absolutely false. So as I mentioned in my opening, Mr. Williams said that he was told that he was going to get a land certificate. Could I now invite the court to go to page 1461?
Yes, Mr. Courtney.
And the only point I make here on 1461 is there was a rental management agreement, which he said he was given 4 days to sign, and he was quote unquote under duress because he had 4 days to sign it. And he got an email after that saying to him, listen, you haven't signed. Are you going to sign? $14.66.
Yes, we're there.
At line 15. Before you have affixed your signature to the order form and your initials to the summary page, you knew that the funds were going to be wired to Green Development Partners via Beltway Investment Group, correct? Those are the instructions we were given, yes. I know those are the instructions you are given. I'm asking you if you knew it prior to affixing your signature on the order form or your initials on the summary page. You knew that this is where the funds were going. Yes, thank you. Now, Mr. Williams, you elected to pay a lump sum payment, and in fact, you did not pay a lump sum payment, correct? Correct. Point being made, he knew exactly where he was going to send the money to Beltway, and that Beltway was going to get it on behalf of Green Development. Page 1491,
Sorry, Mr. Courtney, could you just repeat the page number you just mentioned?
1491.
Thank you.
At line 16, you will recall that in or about September 2019, there were certain email communication between you and Mr. Helms. You recall that? Correct. Yes, I do recall it. And there were a few conversations between you as well, correct? You recall that? Yes, I do. And the subject of those conversations was the resale of your interest in the property, etc., in the house, lot 259 Keeping Street. You recall that? Yes. You do recall that during telephone conversations, you had asked for a refund of the funds. You recall that? Yes, I do. And it was explained to you that the refund was not possible because the payments were already made. You recall that? Yes. And what he in fact said to you was that the lot on which the building was to be constructed was immediately purchased. So he was saying that the funds were immediately applied as follows. And then he explained the process, correct? I don't recall exactly what he said, but that sounds correct. Yes, well, I put it to you that the process that he explained is that the funds are immediately paid towards the purchase of the property for $150,000. You recall that? Yes, I do. The seawall is purchased and installed, which is about $15,000, correct? I don't recall all the specifics of what he listed a bunch of costs that the developer has when the funds are paid, but stated that those costs have been incurred already on the property. Yes, and I just want to put it to you. If you don't recall, you can say it so. So he said that the seawall is usually purchased and installed for $15,000, correct? Again, I don't know the numbers, but yes, he listed a bunch of items. And then he said that construction materials are ordered. Do you recall that, not a figure, but that you recall that he spoke about the construction materials? I don't recall all the items, but he did go through, I think, a very exhaustive list of items. We can agree on that. Okay, well, no, essentially, what Mr. Helms was saying to you is that the funds get to work immediately, correct? He was saying that, but it was not true. But I'm not asking you if it was inaccurate. I'm asking you if it was utilized. Yes, he said that. And Your Honor, in the interest of time, I won't go over the page, but I invite the court to continue to read it. The essential point there is what I believe Justice Barrow asked. And there he's saying that Mr. Helms put a proposal to him to resolve the issue. And specifically, he said he's not interested in it. Again, page 1498. At page 1498 at line 6. Now, Mr. Williams, I want to take you to the, you did not personally meet, I guess that's where it should be, meet Beth Clifford before signing the order form, correct? That is correct. You never spoke to her before signing the order form, correct? Correct. And in fact, you never spoke to her before signing the construction agreement, correct? That is correct. And Beth Clifford, personally, Mr. Williams, if I can take your attention to page 10 of the record, can you look at there for me, please? And then there's a discussion about the thing. And then on page 1499 at line 17, and you recall that there were various communications going back and forth regarding execution of the land transfer documents and transfer of title. Yes. So I just want to make one point before moving on, that Mr. Williams did not have any dealings with Ms. Clifford prior to signing. Your Honor, in the interest of time, I ask you to make a note of page 1499, 1502, and 1503. What 1502 and 1503 show in summary is that the share transfer documents to the Anguillan IBC were sent to Mr. Williams. Mr. Williams signed them and returned them, i.e., on behalf of the respondent, he accepted the shares of the Anguillan company. It was subsequently voided. The reason is irrelevant. The effect of the voiding of it was that he did not get title. And it is for that reason and the delay that he commenced the litigation. Your Honors, our respectful submission is the totality of the evidence shows from the witness statement and from the cross-examination.
Mr. Courtney, just indulge me a little bit. Why was that share transfer subsequently voided?
Your Honor, there is a debate about it. When I say debate, I mean on the evidence and the submissions. Our case is, as I understand it, that Mr. Williams was the one who asked for it to be voided. That is a little difficult to comprehend. The case of the respondent, speaking on behalf of my learned friends, is that my clients voided it. You will see in the evidence, Your Honor, discussions about some problems with the Anguillan attorneys. Being frank, I would say that it was voided because of difficulties that my clients were having with their Anguillan attorneys in terms of completing the transaction. I don't think the court rejected the notion that it was Mr. Williams that asked for it to be voided, and I don't think that one can argue against that. So clearly it was my clients who, for whatever reason, difficulties they were having.
I think the High Court found it preposterous.
Indeed. So, Your Honors, the point about that, however, is I believe it supports my submission that but for the delay, Mr. Williams would have accepted the shares. He in fact accepted it, but it was then voided. But for the delay, this transaction would have been completed. I say specifically, you will not find in the evidence of Mr. Williams, cross-examination or evidence in chief, any argument from him, any evidence from him that he was confused or misled or was a fraud was perpetrated against him, save and except he says he was told that he was going to get a land title document and not the shares to the Anguillan company. Other than that confusion, it was absolutely clear to him, a man of more than 25 years experience in real estate, exactly what the transaction was. Your Honors, I say against that evidence, the notion about confusion, the notion about fraud, the notion about being fraudulent misrepresentations are arguments constructed by counsel that are divorced from the evidence of the respondent and divorced from the evidence of Mr. Williams. Mr. Justice Balkan in the Court of Appeal found that Miss Clifford being the sole director, Miss Clifford being the sole shareholder of these companies, Miss Clifford having different roles in these companies, Miss Clifford having up to 100 companies, Miss Clifford signing documents with different signature blocks, all constitute sufficient impropriety necessary for piercing the corporate veil. He says that at page paragraph 112 of his judgment. Your Honors, with due respect to the Court of Appeal, we submit that there was absolutely no basis to quote unquote pierce the corporate veil.
Mr. Courtney, before you move on, it looks like you're wrapping up that submission. You talked about the numbered company, and you talked about the rental agreement. Can you tell me what's going on in this rental agreement? I think you can find it. The appeal record, page 239. I want to make sense of that. And I'll be taking you to both appeal record page 239, and it concludes at appeal record page 260. So let's look at those two, the bracket information I've just given you, 239. Are you there?
Yes, Your Honor.
This is the rental management agreement, isn't it?
Yes, Your Honor.
You referred to. It says unit owner is a numbered company. Is that correct?
Yes, Your Honor.
And if you go to page, I think the document ends at record appeal record page 260. It's a long document, so I have to write 260. The date of that signing is, I believe, the 14th of June 2017. Who does it say the unit owner is there?
Well, Your Honor,
What's going on?
no, because again, you will see in the cross-examination of Mr. Williams, there are several pages where counsel was saying to him that he operated as if he owned the numbered company and that he was operating as the director of the numbered company. In order to establish that, she took him to these very documents and said, look, you see, you have already signed as the director of these companies. So what Mr. Williams signed here as is the director of the Anguillan company, which was the unit owner. Of course, it was before he actually received the transfer of title.
Thank you.
Yeah,
So-
Mr. Courtney, as you deal with this topic of this issue of whether Justice of Appeal Vulcan was correct to pierce or lift the corporate veil, could you as well let us know what you think would be the appropriate test for this court?
Indeed.
Not quite what was said in press, but what should we do?
I will endeavor to present the court with phraseology. Your Honors, first of all, just to be clear, we rely on press and we rely on just the assumptions, articulation of what is required for the piercing of the corporate veil. I put the submission in this way. There is no case where the corporate veil is, I prefer to say lifted, but lifted or pierced, where a company is liable for some obligation, restriction, or liability, and the corporate veil is lifted and the shareholder is then personally held liable for the debt of a company. That is not an application of the principle, and indeed in press, and particularly the president at the time, Neuberger, goes through the cases and explains why that is not the application of the principle. How does the principle operate? One, a person has to have some liability, some obligation, or some restriction. Because he or she knows that, he or she forms a company and uses that company in such a way to frustrate or to evade that liability or obligation.
What
The bill-
about where, Mr. Courtney, what about a scenario where somebody before the legal obligation or restriction actual arises? What about in anticipation? I'm not saying that is the case here with your client, but I'm trying to test the limits of Lord Stumpton's thesis. What about a scenario where I'm up to no good? I go on and set up a corporation. In other words, that becomes a spider's web for the unwary. And then people fall into that. So there may not have been existing legal obligation or restriction, but that is what the person wants to do. So they set it up ahead of time, advertise their scheme, and people fall into that trap. Are you saying that corporate veil may not be lifted in those sorts of circumstances?
That is my respectful submission, Your Honor. And the jurisprudential basis in that scenario is principal and agent. And that is revealed, as Lord Newberger points out in press, in the case of Guilford. Because the facts of that case, he was an employee of a company. He left the employment of the company with a restrictive covenant. In order to, quote unquote, violate that restriction, he established a company. So he established the company with the intent to go, to use Your Honor's word, to get up to mischief.
But he already had the restriction before he set up the company.
Right, but what I'm trying to say, two things. One is, as all the cases say, these things overlap. The fact that it is, and I say it makes no difference if that he did not have that prior restriction. If I set up a company with the intention of doing wrong, that company is the instrument through which I, as principal, am using it as my agent to achieve wrong. Lord Newberger discusses that in press, and I am submitting to this court that in the scenario that you just gave, Justice Ibo Osuji, the jurisprudential basis of finding the company liable is principal and agent, not piercing of the corporate veil.
And on that note, I hear you. On that note also, a related question, you're not disputing that agency can be in play.
Yes.
So then I take it then a corporation being an independent legal personality in the same way as a human agent or two humans, one principal and the other agent, are independent human personalities or legal personalities. A company can be an agent of a human being.
Yes.
In that scenario, then, what is wrong with a claimant claiming against both the human person and the company, saying, "Well, I'm not interested in lifting the corporate veil. It can keep its corporate veil all it wants. I just want to be able to sue both of them." What's wrong with that?
There's absolutely nothing wrong with that, Your Honor. And that is what was done in this case at first instance. The problem in my respectful submission is the delta between making that claim and providing the proof. You can't just say, and I don't want to turn it up at this stage, but in Summon and Summon and in press, it repeated several times in both cases, the fact that a person is a director and a shareholder of a company that conducts business, and the fact that you are the directing mind that is insufficient to establish the principal-agent relationship. You have to go more. And Your Honor, the question you raise, I think there is one layer that has to be added to it, which is the principal-agent relationship has to be that the agent is now we're holding the agent responsible, not just the principal. The agent has done something, breached a contract, the agent has committed a tort, etc. In order to visit that on the principal, i.e. a shareholder or director, you cannot simply say you are a director and shareholder, and therefore, because the company did A, B, or C, you are liable because you are the sole shareholder. You are the one who said, go and do this. You are the one who signed the contract, etc. It is not sufficient. Otherwise, someone will fail in every
You know, the
scenario.
thing, the problem with Salmon and Salmon, as I read it, and of course we all read that
The problem
case
with
first.
that,
The problem with Salmon and Salmon, excuse me, as I said, we all read it in the first lecture in company law in the university, is the agency difficulty in that case was not resolved. It was glossed over. In the sense that if you took what they were saying, what Lord Halsbury was saying in that case, you would never find a scenario where a human agent could be a human can be a shareholder or director could be an agent of the company. But I don't think that follows from the original premise of that case. What am I saying? There's a difference between you holding a share of Apple computer, for instance, and somebody wanting to go after you, versus Steve Jobs, for instance, being held accountable as an agent of Apple. So those are not the same scenario, and I don't think that Salmon and Salmon resolved that question, that conundrum. It was just an assumption that because somebody is a shareholder, they cannot be an agent.
Your Honor, I will not seek to persuade you otherwise from what you have said. I accept that an agent, a shareholder can in certain circumstances be an agent, depending on the factual situation, and it is very fact specific. Secondly, I accept that Salmon and Salmon does not resolve the issue. What I would rely on Salmon and Salmon for, and press, is to say that it is not sufficient to say that because you're a shareholder and a director, that is enough to establish the agency, principal-agency relationship. You must go more, and you must show. Can I just very quickly bring it to this case? Step back and ask the court on the facts of this case, not the arguments that were presented, the facts of this case. What is it that Beth Clifford did to make her the principal and these companies her agent? Purchase and sale of property. There was inordinate, inexcusable delay, which happens often in construction, and the party rescinds the agreement. There is no evidence that she has sought to avoid that. She has defended it, she has lost, she has accepted it. When I say she, I mean Green Development. But you examine the evidence and you will not find anything that she does. She did not negotiate this contract. She met him a couple of times during the course of the delay and sought to provide an explanation for the delay and try to justify it. That is reasonable. That does not make you the principal and the agent. My submission, Your Honors, and I'm running out of time, is that for there to be a lifting of the corporate veil, there must be a pre-existing liability, restriction, or obligation, and you interpose a company in order to avoid or evade or frustrate the enforcement of that liability. What we have here is what in Rosendale and in Persad, a reverse piercing.
Mr. Courtney, before you wrap up, I really just wanted to ask two quick questions. One, I know we are not relitigating the breach, but I just want us to recall what the breach was. Was the proven breach the breach of an implied term in the contract? for GDP to deliver the land purchase agreement. That was my understanding of the proven breach. Was that the breach that was proven?
Yes, Your Honor.
Okay. And so in this case, the second question that I have is we were having a bit of an exchange on principle, the notion of agency. In the statement of claim, as I recall, the allegation of agency was made. Was the finding of, was the corporate veil ultimately pierced and liability, personal liability established on the basis of agency?
Well, Your Honor, I would be more specific on that issue. And I would ask the court to take the note because I counted it. The word agent is used 12 times in the Court of Appeal judgment at the following paragraphs: 35, twice in 37, 97, 99, 106, twice in 108, 115, 116, 123, and 128. In none of those paragraphs is there a finding of the companies being agent of Ms. Clifford. There is no such finding in the Court of Appeal judgment, and there is a finding to the contrary in the trial judge's judgment, and there has been no cross appeal to this court on the lack of a finding in the Court of Appeal of an agency principal relationship. I hope that answers your question, Your Honor. The piercing of the corporate veil was not on the basis, to be specific, of a principal agent relationship. It was on the basis.
Yeah, sorry. No, go on. Finish.
Yeah, just finishing a sentence. It was on the basis of quote unquote impropriety being found. And the impropriety is settled by Mr. Justice Balkan and my learned friend's submission, what they allege to be the impropriety. And I say to this court, and I submit to this court that when you examine the so-called impropriety, it is criticisms, extensive criticisms of the agreements, extensive criticisms of the agreements, but there is no reference to Mr. Williams. There is no reference to Mr. Williams. Any of these discussions about how many companies there were, who could enforce what against which company, the companies were not parties, how the money was wired. Mr. Williams, in his evidence, does not complain about any of that. Sorry, Justice Chamada.
No, I just want to clarify that for you, the piercing of the veil or the lifting of the veil can only arise in a scenario where the existing liability obligation, there is an existing liability obligation restriction, and subsequent to that, a company is formed to avoid.
Or to frustrate.
Or to frustrate, yes, sure enough. So
Yes.
that in your understanding, you cannot have a scenario where a company exists and let us assume that there is post-existence of the company. I'm not saying this is the case here, this is just theoretical to be clear. Post-existence of the company, post-incorporation, there is fraud, proven fraud. Are you saying that in such a, I'm using the extreme example so that we don't get into unnecessary debate. Are you saying in such a scenario you cannot lift or pierce the veil? Where the fraud is done in order to avoid an obligation or liability or so?
Your Honor, the question is, if the fraud is done, there is a jurisprudential basis on which to hold the company liable.
No, I understand that. Yes, under the Companies Act, if there is fraud, I understand that. But I'm not asking that question. I'm asking a different question. I'm asking the question because you set your premises in a certain way. So I'm just trying to ask you whether or not, assuming the pre-existence of a company, but subsequent to that, there is fraud to avoid an obligation or liability. Can the veil be pierced in order to go after the director or a shareholder, as the case may be?
Your Honor, on my submission, based on press, etc., that will not be a scenario in which
Yeah, right. No, I understand
the
that.
corporate field as defined in these cases. I am not to be understood to say that there will be no liability.
No,
But
I know.
not
No,
true.
our
Yes.
conversation is simply on when you can lift or pierce the veil. That's all.
Yes.
I understand that. So let me just ask you a slightly different question then. And I accept that you have also said that you adopt press and law assumptions articulation of what is required. So, and this is just for my benefit. So what do you do with what the other judges did? Because the other judges had Lord Walker, Lady Hale, had serious reservations about the formulation of the test, as to whether you could even formulate a test, etc. And so would you say that given that state, what I want to ask you is whether given that state, this court has a duty, if it is going to develop or discuss or state the jurisprudence on piercing the corporate veil, to articulate what its test is?
Your Honor, the answer is unequivocally yes, but I just wish to remind the court that certainly Baroness Hale and Lord Newberger said specifically that they agreed with assumptions, just assumptions, articulation, but they went on to then make other criticisms and raise other points. I only say that to say that the majority specifically said that they accept that articulation.
I thought they only, Lady Hale said she agreed with the conclusion, but I thought she had some questions about the tests. What are necessary to, yes.
Sorry, just to I don't want to dwell on it because I just want to get maybe for the record where you are on what we can and cannot do in this case. That's all. Because I'm not trying to persuade you away from your views at all, Mr. Courtney. For example, Lady Hale would suggest that there is a better grounding for piercing the veil, which is a test of unconscionability. And I'm not suggesting that should be the test necessarily. I'm just saying to you that my reading of Prest is not as neat as maybe yours is. And that's why I asked whether you feel to decide this case as part of the ratio, we need to decide what the test is, because it would seem to me that we cannot get to the facts to say what the facts are or are not until we state what the law is and then apply the facts to the law. So that, for example, if the test requires principal and agent, we need to say that and then say there is no evidence of principal and agent. Agreed?
Agreed.
So that the first step we need to take is to decide the test, then find what are the facts. You have helped us with that, thank you, and try to apply them.
As all the cases say, this area of the law is difficult and unsettled, and I respectfully say that this court has a duty to articulate for the Commonwealth Caribbean or for our jurisprudence what the test is for piercing the corporate veil, or lifting, as I prefer to say, lifting the corporate.
And to end this conversation between us anyway, would you say that exploration could include whether it is limited in the sort of synergistic formula that you created, you first have a liability obligation and you subsequently create or incorporate in order with the specific intent to avoid, as opposed to the an option on another possibility, which is you have a pre-existing, but you then, as I said, for example, use fraud to avoid, etc., etc. Would that also be something that could fall within what we should consider and discuss?
In my respectful submission, Your Honor, yes.
Okay, thank you.
And
Sorry.
can I just say, I think one other issue that the court ought to consider is the analysis from Prest that it is a remedy of last resort. Is it something that can be taken up immediately and say, I want the corporate, or do you have to exhaust and say, I have nothing else and therefore I can fall back on piercing the corporate veil as a remedy of last resort? Your Honors, I want to make sure I get a couple more things in for the record. One is Persad and Singh supports the submissions that I'm making, as does Rosendale. Secondly, I think it is absolutely important that the court bear in mind that both courts below specifically found that there was no fraudulent misrepresentation. Thirdly, at page 35, paragraph 84 of the judgment of the Court of Appeal, Justice Balkan specifically said, and this is relevant to both Ms. Clifford and to Beltway, but perhaps more to Beltway, that the funds were not misapplied, they were not misappropriated. Fourthly, both courts found that there was no constructive trust on the facts of the case. Your Honor, I close by saying this. The evidence of Mr. Harms at paragraph 66 what page is that?
His witness statement, Mr. Courtney?
His witness statement, Mr. Helms. Paragraph 66 of Helms' witness statement, 581. It's at page 592. Paragraph 66 reads, currently there are now 173 units in the rental inventory of Mahogany Bay Resort, and it is those units that make up the hotel. Mahogany Bay is a Hilton franchise, and occupancy and daily rates are trending in the right direction. We have over 200 units that are fully built, including the lot 259 Keeping Suite belonging to LCW Investment. The remainder of owners either opted out of rentals or are not yet a part of the inventory due to demand. This court respectfully should be well aware that there is a Hilton resort operating with over 200 units, and one breach of contract does not a Ponzi scheme make. Your Honors, I have exactly at my 1 hour. I ask that for the reasons that we deployed in our written case and our speaking note, that the appeal be allowed. We say that there is absolutely no basis to do a reverse piercing. There is no basis to find a principal agency relationship in order to impose liability on Beth Clifford. Indeed, we say it was wrong for Justice Balkan to say that there was no evidence as to what happened to the money. I took the court to the evidence where Mr. Williams accepted in cross-examination that it was explained to him what happened to his money. So in our respectful submission, money that has not been misappropriated, not misapplied, and applied to the existing suite that is there, there is no basis on which, in the circumstances, to visit liability on Beltway, especially where Mr. Williams says, listen, when I got this document, it told me to wire it to Beltway, which will pass it on to Green Development so that it could do the building. The building has been, it's built, accepted, gross delay, but it is there. Those would be my submissions.
Mr. Courtney, one small point. We know what you have said and submitted about some of the findings the Justice of Appeal Vulcan made. But what about the test he laid down? How do you see that? What would you like us to make of that?
Well, my understanding of the test as that is one, two. At paragraph 112, he says, in my view, the combination of all these factors more than meets the test for piercing a corporate field and imposing personal liability on Beth Clifford for the proven breach of contract. It refers to a summon. He says, as discussed above, it is the ownership and control of companies combined with the nature of the transaction itself that establishes the impropriety necessary for piercing a corporate field. Although supposedly separate entities, GDP contracted with the buyer for obligations to be carried out by the companies. How would this be enforced unless there's no real separation between them and GDP was confident that it could ensure performance, etc.? Having regard to all the circumstances as discussed, both the structure of the companies involved and the nature of the transaction, I'm fully convinced that the breach which occurred during this arrangement was obscured by the tangled corporate web. And he goes on, I believe, I was looking for where he says it's in the interest of justice.
And on paragraph 113, you will find words like the misuse of the law to evade the obligations and liability.
Yes.
And using it as a shield for liability. So I suppose in between paragraphs 112 and 113, we will see how Justice of the Appeal Vulcan considers that the veil should be lifted.
Your Honor, the purpose of limited liability companies is to avoid personal liability. That is the purpose of limited liability companies. So to say that I am using my company as a shield, in my respectful submission, is to say that you are using the company for the purpose for which it should be incorporated. That is why we have limited liability. And I think that he was wrong to put it that way. What, in my respectful submission, the test should be, is the following. The corporate veil should only be lifted where a person subject to a liability or restriction forms a company and uses that company in order to evade or frustrate that pre-existing liability. An essential element is that the company must be used by the person subject to the liability or restriction in an improper way. That is to say, to avoid, to evade, to frustrate the law.
Is the word you're looking for bad faith?
And it can be worse than that. I think Justice Jamala raised a question of fraud as well. It is to make mischief, to do bad faith, to act in such a way that I am using the company, and this is where I think a part of what Justice Balkan was referring to. That company is being used specifically for quote-unquote mischief. I don't want to repeat myself. On the facts of this case, the companies were being used for a legitimate business purpose, and for whatever reason, there was a delay which is inexcusable, which has been accepted. There is no evidence in my respectful submission that these companies were being used to evade, avoid any obligation.
Yeah.
Your Honors, unless
Yes.
I can be of any further assistance, those would be my submissions.
Thank you very much, Mr. Courtney. I don't know if my colleagues had any questions for you. It appears not, so I thank you. Mr. Marshallek, the floor
I'm
is yours.
invested.
Thank you very much.
Thank you, Your Honor. Your Honor, the appellants seek to put the principles governing lifting or piercing, I'll use them both, because there are differences in the meanings, and there have been many judgments written as to exactly why they mean different things. The corporate veil into a straitjacket with dimensions defined by reference to the evasion and concealment principles described in Prest by Lord Saltworth. There are two problems with this fundamentally. One, in the first place, Prest itself does no such thing, doesn't confine it to those principles. And the second is that Prest should not be adopted without a searching examination of the principles that underlie that test, as well as to its practical utility. And those words may sound familiar because they came from this court. Your Honors, before I go to Prest, which is the heart of the matter, I do want to clarify and correct certain submissions that have been made in relation to the facts and the evidence. The first, according to my notes, is that this building has been built and is ready. That's not quite true. A building has been built, it's unfinished. That's the evidence of everybody. In fact, there are photographs. I'll give you the reference to the photograph shortly. I believe it's page 567 of 825 is the top number. You'll see what's there. And
Sorry, did you say 557, Mr. Marshallek?
567?
Thank you.
567. And the paragraph reference in the witness statement. Get that reference to you shortly. Is that it's substantially complete.
With a statement of whom, Mr. Marshallek, please?
Beth Clifford, this is the
Okay, thank you.
appellants themselves. They've never said that it's finished. They said that it's almost finished. And
What date are these photos taken?
Yes, and that's the crux of it, because when you go through the details of this, you will see that this was done after the notice of rescission, not before.
Yeah, but
So the notice of rescission was in August, and these were done in December 2019. So there was a rush to do certain things.
Mr. Marshall, 1 second, please.
Yes.
Were these photos taken in 2019 or at the time of the trial? Because the reason I ask this question is the evidence of Mr. Helms, I believe, said as of today, we have 200 buildings. are you saying that these photos were taken as of the time Mr. Helms was referring to, or before?
Yes. Time of trial, just before trial. So I want to
Just
make
for
that,
purposes of my record, just before trial, what year was that?
give me the date there for scenario. I believe that would have been 2022, 2023. I'll confirm. I think
The
trial was
next-
in 2023.
Next question for you, Mr. Marshallek, is, will these photos be representative of the entire Hilton Resort? Or could it be that this could be that Hilton Resort continues to build as we speak, even today?
That's a part of the problem, you see. The Hilton name is thrown around. They don't have a resort. They have a relationship with Hilton under which they use the brand
Whatever it
name.
is. Yeah, now let's forget about Hilton
Sell
Resort. Okay,
accommodation. Hilton hasn't built a
Mahogany
thing.
Bay.
It's Mahogany Bay Resort.
Yes.
Yes.
Question is Mahogany Bay. With these photos you showed us, with the entirety of Mahogany Bay, as at the
No.
time of trial, or would it just be that it could be that Mahogany Bay continues to build, so that they may already have 200 units completed, as Mr. Helms testified to, but then these are further buildings besides those?
I don't know. This is the photographs they put forward to show where things were at the time of trial. This is the appellant's own evidence.
But Mr. Marshallek, you're saying the photos referred to on page 567 of the record of appeal were apparently taken in December of 2019.
Yes, they were after.
Thank
The
you.
testimony is that it didn't reach that stage until December 2019.
Thank you.
There is extensive cross-examination on it of Beth Clifford. And I want
I
to
don't want to
urge,
cross-examine you too, Mr. Marshallek, please.
yes,
I just want to understand what we're looking at. If you looked at page 571, what is that showing us? There's a photo there at the bottom.
that's showing a portion of the development.
Do they look complete or completed, as you see?
Your Honor, I imagine a lot of them are complete, but you can pan the camera to the other side where none of them are complete.
Thank you.
Your Honor, what I was getting to, I was pointing out first of all that it's not complete, and then there's the timing of when it got to that point. The evidence is that it got to that point well after the date notice of rescission had already been given. So it was an attempt to be able to come to trial to say, I have it complete. It's neither here nor there, but you must bear that in mind when considering the arguments presented by my friend. The next thing I wanted to point out was that there has never been any suggestion that liability should be imposed because of any confusion on the part of LCW or Mr. Williams. My friend has found it convenient to demonstrate through many references to the evidence that there was no confusion. Well, it's also stating the case in a way that's favorable to his clients and then demonstrating that his statement of it doesn't hold water. That is not the case that was presented. Mr. Williams never did come and say I was confused as to any documentation. The convoluted documentation is acknowledged in his description of their strangeness. But when you read the terms are also inconsistent and convoluted. There is also a fundamental difficulty here in the scheme that as my friend described it to your honors. He described it as They were to build a house. They were to then transfer title when it was finished. That is entirely not the scheme of the convoluted contracts, but it may be the convolution of the contracts that leads to that misconception. You see, what was to happen is what is logical. There's no way LCW will pay to build a house on land it does not own. You were supposed to present a land purchase agreement, close on the land purchase, present title to the construction company before construction was to commence. None of that ever took place. And the rush to build was to build on land owned by, ostensibly, according to them, if they're to be taken at their word, by GDP itself. And that rests on what was initially a company held with a bearer share, which has never been presented by anybody.
Is it possible?
So
Mr.
let's start there.
Like, one question to you, please. I'm trying to understand this case as council continue to argue it. You said that the condition precedent was that Mr. I believe that was in your submission, written submission. It looks like you've said the same thing now. Condition precedent was that there should be ownership of the land before building commenced. Assuming that to be your submission, is there such a thing as somebody wanting to buy the sausage without wanting to know how the sausage is made? In other words, I'm interested in the building in the resort. Like, just give me a building, however you make it happen. Is it possibly part of the case?
The building goes with the land. It's affixed to the land, becomes a part of it, arguably, because these buildings are lifted into position. So there's a case that can be made that they're chattels. So what there is an agreement to buy a lot of land and to build a building on it, and then separate agreements for those buildings to be used as part of hotel operations by a company which markets them under the brand name of the Hilton, markets them to tourists. That is what is the scheme. When you look at the contracts and the documentation, the mechanism to achieve that is questionable in a number of regards. But just to point again, and I'm just laying out my differences with how my friend presented the facts, because there's a fundamental difference there between the notion that buildings were to be built and then land transferred, and there was a delay in building the building, and certainly there's a delay and they take responsibility for that. And that's what this case is about. Well, it's not quite that. What there was that they committed to present a land purchase agreement with the landowner first, within some 10 days, I believe, of the order having been made and payments having been made. And then they were to complete purchase of land and then commence construction of a building on land owned by the claimant. But what happens here, and this again is fundamental, and it really can't be missed, and I want to take your honors to it, is that when the funds were received, this house deposit and land deposit, they were immediately co-mingled by GDP with its funds and treated as its own. And it is for this reason that it cannot be said, and there was no evidence of, and the Court of Appeal was absolutely correct in finding that there's no evidence of what became of LCW's funds. I want to take you to paragraph.
Was it in relation to all of the money or a portion of it? Because
all of the money.
All of the money.
Yes, 1480.
So, yeah, where the the defendants in the case, were they entitled to use the bulk of the money? I think $640 something thousand to build the lot. Were they allowed to do
was
that? Or was it contemplated that's what they would do?
No, because the obligation was to present a land purchase agreement, purchase the land and then to build. So you can't take the money and just build a lot without complying with the provisions for the acquisition of title to the land.
But Mr. Bachelor, let me understand. The purchasers, your clients, paid the full sum for both
Yes.
acquisition and construction.
Yes, to GDP,
Yes,
the
of
land
course.
construction company,
Right.
which disavowed
And-
any responsibility in relation to the land.
Right. And your understanding or your interpretation of the facts, your understanding is that this was to happen in a certain order, i.e., the title was supposed to be vested in your client, and then subsequent to that, the construction commenced.
Yes.
Right? Yeah. So I just want to ask something. Mr. Courtney told us a bit about the presentation of the shares and then the voiding of the shares and so. So there are two things at play. Before you come to that, something was supposed to be done within 10 days of the payment, right?
Yes,
Right. What was that?
that was the breach that was found by the trial judge.
No, I know, but what was to
Yes.
be done?
It was to present a land purchase agreement to
And so that would have been to complete the first. I'm just looking at your scenario. That would have been to complete the first part of what, in your understanding, had been agreed to do, i.e., basically to move towards vesting title in your client.
Yes,
Right.
and that would have set out the terms and conditions for disbursement of the land price to the land company.
Right.
In the end, the disbursement that Mr. Courtney glossed over so easily was for 150,000 when the price agreed was at 130. Beth Clifford says she took up the difference personally. So that wasn't a disbursement of LCW's money.
What I'm trying to understand is if that document was to both deal with title and set out the terms for construction, that document was never, that's a breach. That document was never procured or completed, right? Is that right?
There is a qualification I must make to what you said.
Yes.
The order form contemplates that within a number of days of the order having been put and the money is paid, two agreements would be presented. One, a land purchase agreement, and two, a house construction contract.
Right.
The house construction contract was in fact presented and signed, and that has the details as to when construction was to commence. And that is what ties back to title having been had. It all proceeds on the basis that the purchase would have been completed, and that only makes sense. There's no way I'd pay to build a house on land I don't own. It just makes commercial sense. So two documents were to be presented after the order was put. One, and notice that those funds were called deposits, not payments, deposits. The land purchase contract was to deal with how the land deposit and the land price was to be paid. The house construction contract then deals with how the house construction price, the house price, was to be used to realize construction of the units ordered. So what you have then is an order form, order summary and order form, the actual land purchase agreement, and the actual house construction agreement.
So, Mr. Marshall, I suppose what I am trying to discover is this just a botched, messed up transaction? Is this even, suppose it's carelessness or whatever?
No.
What gives this qualitatively? What gives this? I'm calling it the botching up. Because in a way, Mr.
Yeah.
Courtney, I get it that he neatly puts a delay, but he doesn't see. I mean, he's an advocate, so he's just going to say delay,
Right.
let's move along. You're giving us
Alright.
particulars, but in your particulars, what gives the botching up the qualitative nature that allowed the Court of Appeal to take the step of, whether you say lift or pierce, the corporate veil?
This is where I'm going.
All right,
And that's
okay,
where I
all
was
right. Sorry,
going.
yeah, I'll wait
Yes.
on you, yeah.
The heart of that lies in the commingling of funds and the fact that there are only funds available to effect the constructions if there are new orders coming in. When new orders stop, you're unable to deliver. And some people will describe that as a Ponzi scheme. And we've cited authority for that description. In the second case concerning documents of this very type, this very developer, but with another purchaser, before another judge. And that is
Mr.
the
Marshall,
affinity
I think
decision.
before you rely on that, is that case not under appeal?
No, not yet.
No, sorry. When was that? I have not read the case. I've just seen reference to it in your reply submissions,
It's
your
brand new.
skeleton.
I don't think the time for appealing has yet run.
I see. So the finding of fact that it was a Ponzi scheme, I looked up a Ponzi scheme and I have my reservations about the use of the terminology. But
Yeah.
since that case may come on appeal, perhaps we should stay away from it. Yeah?
Yes. And you would have seen that the description of the judge there was that it was like one. So that
No,
the
I think he said it
variation-
was like a Ponzi or a pyramid. Yeah?
Yes.
So he has not
In effect.
distinguished between the two of them. I went idly into Google and saw the difference between the two. One is an investment situation where you invest money and you get a return. The other is where you are paid to recruit people. So let us stay away from that because that may come up before us.
It indeed might, and there are a variety of species of them. So
Mr.
requires
Marshall, and
more.
so, yeah, Mr. Marshall, I thought what you may have wanted to do was look at what Justice of Appeal Bolton did. Because
Yes.
as I understand it, you've not appealed.
Yes.
You've not cross appealed to us.
No, we say he was
I may have
quite correct.
missed it. Yeah, I may have missed it, but I didn't see, was there reference there to anything that was a Ponzi scheme or a pyramid?
No.
And what about fraud and misrepresentation?
I was answering a question as to what is it about this transaction that takes it out of the realm
Yes,
of just
and that's
simply
where I am
a
too.
botched arrangement to something else that would require piercing of the veil. And this is where I've been trying to take you to the reference which describes what happens to the money and how the scheme was in fact utilized.
Yes.
And it is paragraph 1480 of the record, paragraph 5 @C, and that takes you to Beth Clifford's testimony. And this is also in response to the suggestion that there is evidence as to what happened to the money.
Sorry, please repeat the
If you
page
look-
number.
Sorry. The top number is 1722 of 1725. 1722.
Thank you.
And this is the cross-examination of Beth Clifford. It said, so we included in 259 in the construction of long lengths of seawall were all the items you enumerated that you commenced in May 2017 paid for out of the deposit by Mr. Williams? No, you asked me when I commenced, so that is not the exact date. We did all of them. We commenced construction and property. We did do the seawall in that time frame. Then we continued to order materials, etc. Once the 8CA was received by us, we did do the seawall because we were doing a long tranche at the time, a long length of seawall at that time. Did you pay for the seawall out of Mr. Williams's deposit? as the Director of Green Development Partners, we paid it out of funds available of the company. We do not sequester funds to be specifically spent. Is it your testimony that all these deposits are commingled, Ms. Clifford? Yes. And is it your testimony that you regard these commingled funds as belonging to Green Development Partners Limited? As the Director of Green Development Partners, I consider the cash on hand to be property of Green Development Partners. Is your answer yes, Ms. Clifford? Yes. Thank you. So the point I'm making is what takes it beyond the character of just a botch is the way they was commingled with all the developments within the within the Mahogany Bay Resort development, the picture of which Your Honor pointed me to. The funds for all of those.
Mr. Mashalek, how different really, qualitatively, is what you've just described, taking us through the evidence. How different is that from what banks do? Banks take money from their clients and they lend out that money, and then lend out the money. And if everybody at the same time say, okay, we want to go and collect our money, the banks will crash.
What it
Does
is
it mean that
there's
banks are engaged in fraud?
No, there's a legal basis for that arrangement, as Your Honor is well aware, that when funds are deposited with a bank, the bank borrows the money from the client, from the customer. So it's treated as bank's money, and it's replaced with an obligation to repay, just as if it were a loan. And that is the basis on which banks can treat with that money thereafter as if it was its own.
But
There's
that's
a fundamental.
That is co-mingling.
Yes, but it's commingling its own monies that it has borrowed from a multiplicity and variety of different people. The basis of it, of the taking of the money from the client, is a loan. So banks borrow money from its customers, and that takes it completely out of what you're dealing with here. In fact, I can tell you that in Canada, there's legislation.
Mr. Marshall,
Sorry.
just so I understand your point. Your point is that your client paid money to get land and for a specific building to be built on lot. What is it?
59.
I forget now. Yeah, 259. And that the use or part use of that money for a purpose other than what it was sought for and given, you say that takes it outside of the realm of a botched transaction or just incompetence and so on.
Yes.
There's an element to that you say, but you haven't alleged fraud, but you say it takes it beyond just incompetence and so on. Yeah.
Yes.
So I think I certainly understand that. Yeah.
So then if I can get to the heart of the matter. If you go to Prest, and I wish to make the point first off that the principle of lifting the corporate veil allows liabilities to move both directions. It allows for the liability of the company to be visited on a shareholder, and it also allows for liability of a shareholder to be visited on the company. If you want to call that piercing and reverse piercing, it's a matter of linguistic. If you want to call it founded on the evasion principle as distinct from the concealment principle, it's a matter of linguistics. If you want to call it a lifting of the veil instead of a piercing of the veil, it's a matter of linguistics. Because what it is, and there has been much discussion of it, there is a technical version of a piercing, which defines piercing by reference to liability of the shareholder being visited on a company. But that is not the ambit of the principle. That is only an aspect of it. And what my friend has sought to do is to confine the principle to only one recognized aspect of it, but it's not even the aspect that readily applies in the circumstances of this case, because aspects of this case fit into evasion, but it also fits readily into concealment or into the wider principle of abuse. I want to take you to the latter first because it explains the first two in Press by reference to a reference in Press itself. If we go to paragraph 35 in the judgment of Lord Sumpton in press. And that is page 2401 of the record. At the bottom of paragraph 35, it says, but the recognition of a small residual category of cases where the abuse of the corporate veil to evade or frustrate the law can be addressed only by disregarding the legal personality of the company is, I believe, consistent with authority and with long-standing principles of legal policy. That is a general statement of the principle that governs lifting the veil. Within that general statement is the evasion and the concealment principles. But the evasion and the concealment principles together don't fill the entire space allowed for by that general principle, so that there is a residual category. And the importance of categorization of any particular instance in one or the other category is neither here nor there, so long as it falls within the overall principle. And this principle is entirely consistent and was in fact what was relied upon by Mr. Justice Balkan in the decision of the Court of Appeal, and he was correct to do so.
Mr. Marshallek, you've drawn us to the reference, Lord Sumption's judgment to this residual category of cases, and some members of the bench would have pointed you to other judgments that would have been, other opinions that would have been written in this particular case. I think what unifies many of the judgments is a recognition that piercing of the corporate veil is quite an extraordinary step to take. It's not something to be done lightly. And I also wanted to draw your attention to, and I do agree with you, by the way, that it may not be helpful to be too prescriptive in advance about all the circumstances in which the corporate veil could be legitimately pierced. But I do want to draw your attention to paragraph 34 of Lord Sumption's judgment. It's the paragraph immediately preceding the one that you quoted.
Referred to.
Yes, and this part of the judgment I'm reading from was also quoted by Justice of Appeal Balkan.
Okay.
Lord Sumption opines that there's this broader principle that the corporate veil may be pierced only to prevent the abuse of corporate legal personality. It may be an abuse of the separate legal personality of a company to use it to evade the law or to frustrate its enforcement. It is not an abuse to cause a legal liability to be incurred by the company in the first place. It is not an abuse to rely on the fact that a liability is not the controller's because it is the company's. So the question that I have, Mr. Marshallek, is where one is dealing with a factual matrix like the one we have, where the corporate veil is pierced in order to, as you put it, affix the liability of the company on the shareholder. So we're not dealing with a pre-existing liability of the shareholder, which is being assigned to the company because there is evidence that the company was set up to evade or frustrate that liability, right?
There are aspects of that in one instance, and I've pointed it out in the submissions, Your Honor, and it is that in the use of Beltway, there was a pre-existing liability on the GDP part to use the house deposit in a particular way. And instead, Beltway is interposed there, and the monies are sent to Beltway. And Beltway is divorced from those obligations. There's
But
an
let's
attempt.
deal for a minute with Beth Clifford,
Yes.
because the
Yes.
question of assigning personal liability really arises in relation to Beth Clifford. The
Yes, it
corporate
does.
veil was pierced for the purpose of assigning personal liability to Beth Clifford. I do take your point, Beltway. The issue of Beltway's liability, I don't think Justice of Appeal Balkan was dealing it through the lens of piercing the corporate veil. So what I'm trying to understand is, how does one distinguish? How does one identify? Could you assist us in identifying when it is appropriate to essentially set aside the principle of separate separate legal personality? Because what Lord Sumption was pointing out in paragraph 34 is, where is there an abuse if essentially the principle is operating as it was intended, to ensure that the liability is that of the company and it is not that of the shareholder. So we're not dealing with a case where the shareholder is seeking to have personal liability evaded or frustrated. Justice of Appeal Balkan, in his judgment in paragraphs 112 and 113, would have pierced the corporate veil because he felt there was impropriety that would have resulted in the company's liability being avoided. But one could argue, well, that's the whole point of a limited liability company.
Yes.
So could you help us understand when it's appropriate to set aside the company's liability where there's no question of a pre-existing personal liability? Thank you.
Yes, I can. And let me do this by reference to how the Americans do it, because they have a way of stating things very plainly and effectively. In that jurisdiction, and I will bring it back to ours, I'm using it as an illustration. Undercapitalization of a company is a basis for piercing the veil. Why is that so? The reason undercapitalization invokes piercing the veil there is because if you don't have enough money in your business to pay for your debts or reasonably expected liabilities or to pay your overhead, it is strongly suggestive. This is money and assets to do the very things the company sets out to do. It is strongly suggestive that you are purposefully keeping money out of your business in an effort to avoid any liability. It is not completely unreasonable. I will skip that part, just to emphasize that a company, a properly running company, has to have, I can read the rest, Your Honor, because it's helpful, but I can take you to it.
I was going to ask you, Mr. Marshall, if you could just direct us to what you're reading.
Oh, sorry.
Or what you were referring to.
I'm just reading a description, but I'm using my own language.
Okay, I understand.
I'm using my own language. I'm summarizing it, so I'm not paraphrasing. I'm showing why it is the rationale that underpins why undercapitalization is used as a basis for piercing the veil in the US. And it is because a company is expected to have enough resources at its disposal to do the very things that it holds itself out to be able to do. Now, you can fall short, but when you don't have anything in there at all, when you don't have no employees, when you don't have no office, when you've never paid a cent in taxes, when you don't have a bank account, yet you put the company forward to undertake responsibility to build a $700,000 facility building or buy a $150,000 lot, that venture is undercapitalized. It can't do the very things that it is set out to do. It has no resources at its disposal to do that. And that is seen as an abuse of the use of the corporate structure. And I think informs the rationale that Mr. Justice Balkan sought to explain in large measure for his piercing the veil in these circumstances. But there were a multiplicity of instances of impropriety. And the issue with lifting the veil is while it is acknowledged that the veil can only be properly lifted or pierced where there is impropriety, impropriety. It's not so clear what the bar, the threshold for that impropriety is. Now we know on the top of that is fraud. And we know in the middle of that is dishonesty. But it goes beyond both fraud and dishonesty to catch other things. And if you look at what Mr. Justice Balkan pointed out, those other things, and there were quite a few of them, starting, I think, at paragraph 109, he starts to list what they are, and then he concludes in 112. There are a variety of things, including dishonesty, undercapitalization, and all the other things he described. And one of the major points of dishonesty that he has centers something around which my friend has made a submission in relation to Beltway. And that is that this property was presented to the claimant and rejected by it. And that presentation and rejection has to do with the presentation of for execution of the document of title that was subsequently avoided by his client. So there was no rejection by the claimant at all. That's just misrepresenting what happened. There was no rejection. They took it back, whatever it is they had decided they would give for whatever reasons they had. And there is no argument over what happened there. Beth Clifford admitted in cross-examination that it was them who took it back. And what the judge found highly objectionable is that if you knew it was you who took it back, why do you keep insisting and arguing as part of the case that LCW rejected it? It's a fundamental dishonesty that comes through even, I would say, to now, because the same argument keeps getting made, which is that, look, we presented it, he's the one who turned away from it. And then there's the further argument suggesting that somehow the claimant acts improperly by refusing to participate in a scheme to resell the lot and the building as it now exists and recoup his money that way. Well, that lot and building are owned by the appellants and the GDP. They're free to sell it and pay it back, and they're an obligation to do so. They don't need the agreement of the claimants to do so. They never have. So that is the red herring that's always being pulled before the court. And it is indeed a red herring because what was contracted for has never been completed. And they've never advanced that it has. And the photographs show that it hasn't. So I don't know why it keeps getting pulled before the courts. But it was dispelled very firmly by the trial judge and dispelled in even stronger terms on court of appeal because he saw that as just fundamental dishonesty. Vulcan did. And that comes through very clearly. Jonas, I want to emphasize with regard to applicable principles.
Sorry, Mr. Marshall, before you move on, help me here, because I know you're running out of time. I have been intrigued by paragraph 21 of your written submissions. And if you will permit me, I will skimmingly read it. That Beth Clifford was a single corporator and was in fact in full and total control of the companies, features in the argument for piercing the veil, but is not the substance of the impropriety giving rise to the power to do so. And then you say, it is the common control in the context of the misuse of companies to execute the transactions giving rise to liability that funds the claim for piercing the veil. So as I understand it, it is the misuse of companies.
That derives directly from the judgment of Mr. Justice Balkan.
That's fine, but since you are stating it, I just want to understand what you understand by the misuse of companies. Is it to have a number of companies involved in this transaction? What is a misuse?
It starts off with all communications from Beth Clifford coming over her signature with 3 or 4 companies listed below and never identifying for which one of them she's acting or communicating. That is throughout the whole thing. It starts with a confusion between Beth Clifford, the person, and Beth Clifford, her multiplicity of companies, and it's pellucid throughout her communications that she always is acting in a multiplicity of capacities and never distinguishes for any particular purpose which one she's acting for. So she's merged all of them into one or the other for any of a variety of reasons. It is that none of them has an office, none of them has employees, but they use the offices and employees of other companies, and they move fluidly between all of these different entities. Even in terms of the contractual obligation to pay the price, the additional monies, according to Beth Clifford, came from Mahogany Bay Resort, which had nothing to do with the contracts themselves. The only common denominator among all of it is Beth Clifford. And when you look at all of that, it leads inevitably to the conclusion that Beth Clifford used these companies as her agents and devices to carry forth the scheme that she has put together. The abuse of the corporate structure is a complete disrespect for the separate legal personality of the company. No separate assets, no separate offices, no separate correspondences to customers. Even the employees, the various people who corresponded with Mr. Williams, came from different places and were, according to her, independent contractors from different companies, used to carry forth her very communications regarding the transactions after having taken these people's monies. So when all of that is understood in the wrong, the abuse of the corporate structure is really quite plain and obvious. But I wanted to take you to paragraph 112 of Mr. Justice Balkan's decision to show you where that conclusion came from. Because after pointing out all of these things, this is where he comes to his conclusion. In the middle of paragraph 112, he says, in fact, this was most certainly not the case for the respondent, as discussed above. It is the ownership and control of the companies in ways that themselves obscure their individual identities. And this is what he's getting to. You have one person owning and controlling in an absolute way a vast number of companies. And those vast number of companies in their dealings do not themselves respect their own separation. So in ways that themselves obscure their individual identities, combined with the nature of the transaction itself that establishes the impropriety necessary for piercing the corporate veil. When you go back from that forward, all the way back a number of paragraphs, you see all the variety of instances where the corporate structures were themselves ignored. There was no respect for them, but there was no respect for the obligations created by separateness. But the benefits of them are sought to be taken, and you don't get both. If you're going to be a separate company, then you run yourself like a separate company. You just don't call yourself a separate company when it's time to pay bills. That's abusive.
I have you very clear, Mr. Marshall. Thank you.
Thank you. Thank you. So that is where that comes from. In the wrong, I wanted to emphasize, because of the language of this court where I started, which is that regard must have to an examination of the principles that underlie the press test, which I've already pointed to 35 to show that it's much broader than just the 2 limbs of the test relied upon, and that it is in the broadness of it that Balkan's decision rests, and also the practical utility of it. Because on the practical utility of it, there's a tension created between the economic efficiency of separate legal personality and the need to hold persons accountable for damages caused by wrongdoing. This is the practical basis for the test. The undercapitalization principle, and there's a lot said about it elsewhere, is adopted in other jurisdictions because it's recognized that undercapitalization itself undermines the economic efficiency of separate legal personality. In other words,
Mr. Marshall,
investors.
just a quick question. Are you raising the undercapitalization point to aid the court's understanding generally, or are you suggesting that in this particular case on the record, undercapitalization was established and was taken into account by the judge as a
Yes.
basis for lifting, for piercing the corporate veil?
Yes, both. It's just linguistics. The emphasis by Mr. Justice Volcan that there are no employees, no office, no bank account. All of that are descriptions of undercapitalization. I just use it as a term to capture all of it without having to repeat each and every one of it every time. It's a concept. The concept is that businesses, companies need access to a certain basic resources in order to perform the very functions that they're created to perform. When they're devoid of even that, it is a clear indication that the structure is being abused to avoid liability altogether. Because at the very least,
I take it that you want us to have a look at what Mr. Justice of Appeal Balkan said at paragraph 107, where
yes,
he goes at length into analyzing how GDP was run.
yes. And
Yes.
I've just described some of that as undercapitalization. But I'm not introducing any new idea here. The idea is very much subsumed within the reasoning of the trial judge. I introduce it because it's a term that's used elsewhere, and there's a lot of literature on it and justification for it. But the justification for the elements of it are the very same that comes back when you look at press and the learning in this jurisdiction. It's no different. It's just linguistics. It's just like how the insistent that there must be a pre-existing liability of the shareholder before the veil can be pierced is an argument that can be put. It can be put, but it relies on the definition of what piercing means. And when you define piercing wider to mean more than imposing the liability of a shareholder on a company, then you realize that it's just linguistics, it's terminology. The issue is whether the impropriety identified constitutes an abuse of the corporate structure, which justifies in the circumstances lifting the piercing the corporate veil to render accountability for wrong caused through use of those companies. And that is where you are. And it matters not.
Yeah, Ms. Marshall, I take it that you're saying that that is a test that Justice of Appeal Balkan employed, and that
Yes.
you accept that that was a correct test,
Correct
one,
test.
and two, it was correctly applied.
Yes, and that test, in fact, mirrors the general proposition which supports both categories in press, both evasion and concealment. It's the broader description that encapsulates both those arms. And what it is that my friend has done is to rely on one arm only of press and to say that we're outside the factual requirements of that arm. Well, certainly we are. But that is not the full consideration of what is required when determining whether or not the veil should be pierced. So I just want to leave you with this, Your Honors, because my time is just about up. There has been cases post-press where there's this semantic distinction is sought to be introduced between lifting and piercing. But there's also a recognition that the language is used very loosely throughout the cases. And there's a history of that. so that lifting is used to mean piercing when you seek to distinguish them, and piercing is mean to mean lifting in certain cases. And in the language of press, piercing is evasion and lifting is concealment. When the corporate structure is used to conceal, you lift it. When it's used to evade, you pierce it. It's all linguistics. And it matters not at the end of the day how you seek to categorize it or the language you use to describe it. What you're describing is abuse. Is abuse that's impermissible given the consequences and in the circumstances in which the abuse took place, impropriety. And that impropriety starts at the highest level of fraud, comes down to dishonesty, but goes wider than both fraud and dishonesty. And the difference between the findings of the judge at first instance and the Court of Appeal was that the judge found that there was no fraud. And this is paragraph 27 of her judgment. I'll give you the reference in a minute. And that's all she considered. And she says there was no fraud, so the veil cannot be pierced. But that is an incomplete analysis of it. And that's understandable because this was an oral decision. It wasn't something she sat down to consider to write. It was an oral transcript that was converted to a decision because the judge was about to demit office. What Justice Balkan
I
did
hope you
was
don't
to-
find anything wrong with giving an oral judgment, Mr. Marshallek. I got that sense and I cringed at the thought.
No, it's not wrong, but there is an increased probability that something might be missed when that is done. And that is just human, because while the function of judging is more godlike, we're still human beings at the end of the day and prone to error. So that's how I respond to that.
On the test, Mr. Marshallek, I know you are running out of time, but I was looking at your reference to paragraph 35 and 34. And by the way, I do think that there's much force in your argument that in the last sentence of paragraph 35, that's where the whole thing really lies, of Sumption's thesis. But the recognition, quote, of a small residual category of cases where the abuse of the corporate veil to evade or frustrate the law can be addressed only by disregarding the legal personality. The operative concept there is the abuse of the corporate veil to evade or frustrate the law.
Yes.
Is that a matter of outcome, or is it a matter of intent, intentionality, that whoever is behind this thing is doing it, abusing to frustrate the law? Do we need to look at that, or do we simply say, look, the way the whole thing looked, we have to infer it?
It's both. But where there is intention, the impropriety raises to the level of fraud.
But if
You see,
there's
the abuse encompasses all of it. It encompasses fraud, it encompasses the dishonesty, and it encompasses impropriety. The intention is, if you intended the wrongdoing, you're in the fraud category. It just becomes a more egregious abuse.
Or could
So
it
I'd say it's both.
could it go to the exceptional nature of the remedy we're looking at, makes it needs to be something that heightened the intentionality?
Yes, and that has always been the difficulty. What is the threshold level of impropriety required before you invoke this exceptional power? And I am afraid courts haven't been very clear in drawing the line.
Mr. Marshall,
So
I just
maybe-
want to come back to something that I had asked Mr. Courtney. Because if you say it can be wronged in intention and or effects, then is it that there must be existing liability or obligation, and with that present and existing, you must then in time, in linear time, you must then, i.e. subsequently, set up a company in order to avoid? Or is it that you can have a company in existence, but you set about to abuse the corporate veil and evade or frustrate your responsibilities and liabilities? And in that second scenario, you can also pierce the corporate veil. I asked that question because when I asked it of Mr. Courtney, his answer is very clearly and resolutely only in the former case. In other words, this is a case where the intention alone exists, i.e., I have a liability to you. I set up a company with the singular intent and purpose of avoiding or responsibility or whatever. So how do you answer that?
How easily?
Yeah,
The first
right,
scenario, the first scenario is the evasion principle, and the second scenario is the concealment principle. They're both applicable for lifting the veil. It is not one or the other, it's both. And it is in seeking to confine the power to only the first principle where the error lies in that submission with the greatest respect. It encompasses both. One is described as evasion, and the other is described as concealment. Or if you want lifting or piercing, the first is where piercing is permitted, and the second is where lifting is permitted. It is linguistics. The general principle is whether or not there was abuse of the corporate structure, which justifies to such a level, which justifies the exercise of this extraordinary power. And how you choose to formulate it has to involve elements of both scenarios that Your Honor just described, not one or the other, because they're both abusive.
Is there anything more for us, Mr. Marshallek, or have we come to an end?
Your Honor, I've run out of time. I think we've covered everything, and the court is certainly fully seized of the matter. I don't think there's anything more I can usefully add. This is a vexing problem that's been around for decades, and we're hopeful we'll get a magnificent resolution.
Chair,
Sorry.
would I be able to ask a question about
Of course,
BIG?
yes. Anyone else? Yes, certainly.
Yes, I just
Anyone else?
wanted to explore briefly the question of the liability of, I'm calling it BIG, but Beltway Investment Group. Yes.
Yeah.
Mr. Marshallek, as I understand Justice of Appeal Balkan's judgment, it is really at paragraph 87 that I'm able to discern the basis for assigning liability to Beltway Investment Group, and it seems to be turning on the fact of the full purchase price having been wired from the buyer to Beltway. When I read that in conjunction with paragraph 130, what is being upheld, no, I'm sorry, not upheld, what Justice of Appeal Balkan's judgment does is it holds BIG liable for breach of the contract. Now, the breach of the contract that was proven and is not subject to appeal is the breach of an implied obligation to produce the land purchase agreement. Could you assist me in understanding how being wired the full purchase price from the buyer is a basis for holding BIG liable for that breach of the contract?
Yes, it's something I've grappled with in reading the decision, because there are a number of bases to get to that conclusion. A number of parts, rather. One is to treat both companies as really Beth Clifford as the principal of the entire scheme and activity, so that Beltway is the agent of Clifford, Clifford is liable, and Beltway is likewise liable. But what I want to, that's the easiest path, but what I want to take you to help you understand it is page 232 of 525 of record. And this is the only document that bears Beltway's name and is the basis on which they're involved in the transaction.
Sorry, repeat the page again.
232 of 525 of the record. And this is an attachment to the lot purchase and house construction order form. The order form provided that written instructions for the payments would be given. And these are the instructions that were appended to the contract. When you look at the document, I don't know if your honors have found it, but when you look to the document, set it up Green Development Partners Limited, 10 Monroe Street, Castries, St. Lucia, and it says, to whom it may concern. For all US-based banking, please remit all future wires to the following wiring instruction list below. Beltway Investment Group wiring instruction. You see, it's presented as Beltway Investment Group, and then you look at the signature at the bottom. Beth Clifford, President, Green Development Partners, Caribbean Homes and Exports Limited, Mahogany Bay Limited. It gives the impression that Beltway receives money and is part and parcel of this group that includes Green Development Partners Limited. Now, in explaining how it is that Beltway comes into the transaction, Beth Clifford explained that she negotiated a contract as director of Green with herself as director of Beltway for Beltway to act as an agent to provide what she calls treasury services, to receive monies and pay monies when she says so. That agency agreement which she referred to was not produced, never produced, but she claims it exists in writing somewhere. And it was settled for her in her own terms. But it goes beyond that. The sole bank account to which Beltway, these monies goes, is only operated by Beth Clifford. So Beth Clifford will give an instruction as GDP to pay monies from here to there. And then Beth Clifford, as the sole director and controller of Beltway, and as the only person in control of the bank account, then effects the payment. And when all of that is looked at in the wrong, it's very easy to come to the conclusion that all of these companies are just agents of Beth Clifford. They just do her bidding. Beltway doesn't have an office, doesn't have any employees, doesn't offer any service to the public, does nothing but operates a bank account which Beth Clifford operates. And that's what you're dealing with. I don't know that that helps or makes it worse, Your Honor.
Chair, can I
Yes,
just
certainly,
ask?
yes, it's
I want to ask this of Mr. Marshallek and then Mr. Courtney in your reply, if you also respond. Mr. Marshallek, we're talking here a lot about lifting the corporate veil, and so I just want to know what law is applicable, because as I understand it, the purchasing company is Solution, and then the two companies are American. Well, one of them is now dropped out of the picture. But the agreement said that the law of Belize will apply.
Yes.
So insofar as we have to work out a test, what law, what company law are we applying? I raise that in part because in my reflection on how this can work out, I think the starting point is, and this is so in the Belize 2022 Companies Law Act, it says that specifically, so it's no longer relying on salmon and salmon. It says that a company duly incorporated shall have a separate legal personality, etc., etc., etc. So it gives it the imprimatur of a person. Now, in my own sort of provisional thinking, if it has the imprimatur of a person in law, salmon and salmon, and the section in for example, the Belizean Act, I don't know what the US law has or the Solution law has for the moment.
Well, the Solution is a little more generous.
Well, that's why I asked which law applies. Where are we looking to? But you'll answer that. But what I want to move on to also say is, if that is correct, then if it exists in a territory which is sovereign, it is also subject to the rule of law. And one assumes, therefore, that a company is properly assumed to be incorporated for a lawful or legal purpose and to conduct its affairs according to the rule of law and the general principles of any person And so, for example, when a person enters into a contract, the developing law is that there are certain expectations, one of which is that they will treat the people with bona fides. So it is of interest to me to ask the first question, which is which law are we applying? Because a company is a creature of statute, and so certainly I would want to identify, well, which is the governing statute that we have to look at to see what it may or may not say. That's question number one. And question number two is, if it is that all of this salmon and salmon principle, and we're talking about piercing veils, but before we reach to piercing or lifting, let us understand obligation and responsibility of the person, the legal person, called a company. And to my mind, the almost preliminary or a priori position is that they will conduct their affairs in accordance with law, lawfully, legally, etc., etc. And so, for me, one of the things that I am exercising my mind about is when we come to talk about piercing the corporate veil. If it is that a company is not behaving as a person ought to be in a jurisdiction that upholds the rule of law and must therefore act lawfully or legally, when we talk about abuse of process, how does that feature? Because what you've done is you've said, look, let's broaden this a little bit. Fraud, trial court, you got caught in fraud. It's not just fraud, it's not just dishonesty, it's impropriety. Lady Hale says unconscionable conduct, and so on. So I'm trying to frame it in a slightly more,
Yes.
I don't know how I've tried to describe how I'm thinking about it.
Yes.
Hence my first question, which is the applicable law? And Mr. Courtney, you will at least answer that part of it. The rest was a bit of a diatribe, but at least that part you will respond to when you come to your reply, please. Yes, Mr.
Well, it is something we've considered. The applicable law is, of course, Belize law. But Belize law in dealing with a foreign company is that it's governed by the law of its place of domicile. So your GDP is St. Lucia, so then you go over to St. Lucia. And the St. Lucia one also recognizes, because there is a statutory basis in both for recognition of separate legal personality, as it has always been, because this is an argument that is often put, that statute confers separate legal personality and it can only be removed or disregarded if statute provides so. Well, that's been recognized not to be so. It's been rationalized in any of a number of ways. But I hope I got the first question right, which is that
well, so but
Belize
what about,
law,
but hold on.
But the Companies Act in Belize, Companies Act in Belize isn't defined. Company isn't defined to include a foreign company. So the section that you adverted to wouldn't apply to these foreign companies. The common law, the private international law position is that you go to the law of domicile of each company, but each of them will invariably also recognize the separate legal personality of the companies. But the rationale for stepping aside is the reason lies in the abuse and the nature of the abuse and whether or not the law is being used to achieve a purpose that it was never intended to. And there's an implied provision there that these companies will be used for quote unquote a lawful purpose. And this is and where it's not so used, you can't rely on those statutory provisions. This appears in the Del Peach decision of this court itself, where Mr. Justice Burgess offered a rationale for dealing with it. But it's a problem that's been grappled with from time immemorial. There's nothing new about that, because separate legal personality has always resided in statute. And it's always been to say that for the courts to ignore it is to ignore the provisions of a statute and to tread upon separation of powers, etc., etc. But that being said, the history of the principle and use of it goes back too far to ignore that it exists. What some people find challenging is rationalizing why it's done.
I don't want you to go on and on about
Yeah.
it. I think I understand what you're saying. So these two companies, BT, they are American companies, aren't they? Are they incorporated in the US?
Beltway is US, LCW is US, GDP is St. Lucia, and
So-
they go on, the numbered company is Antigua.
And Willen,
Anguilla,
Anguilla. All right.
sorry. Yes.
All right. And so your
So you're
your
all
short
over the
answer
place.
is we're going to apply Belizean corporate law.
Well, you apply Belize law, but private international law, which then refers you to the law of domicile of each of those companies. So you'll go back to
So
law.
how
of
do we
St. Lucia law.
resolve that one is in St. Lucia and two are in America?
Well, they all acknowledge separate legal personality.
All right.
That was
Okay.
never disputed.
All right.
So there is a statutory basis for separate legal personality. That is so. We would not contend otherwise.
Okay.
well, thank you so much, Mr. Marshallek. And Mr. Courtney, you have a short
Thank you.
reply? Yes.
Thank you, Your Honors. I will be very brief. First point I wish to make is in relation to the pictures, and I won't dwell on it. The document that was being referred to and the pictures that were being shown was a report from GDP to the purchasers, and it shows that there is a resort that exists. It's called Mahogany Bay. It's branded Hilton Curia, and it exists. So I directed you to the paragraph that explains how many units are out there. The picture that Mr. Marshallek referred to specifically to say that there was substantial completion is correct. And when I said completed, again, you will see in the evidence that the agreement itself provided for substantial completion, meaning its erection and emplacement, short of furniture, etc. As he ended by saying on that point, nothing really turns on this, but I am just referring to it because I did not intend to, as he alleged, misrepresent anything to the court. Secondly, goes back to where I started. I listened very keenly and I wrote down very little of the submissions of my learned friend, because once again, it is my respectful submission that when one listens and read those paragraphs of Justice Vulcan's judgment and my learned friend's submissions to you, and you step back and ask yourself, so what? This whole notion that companies are moving between different companies, money is moving from one account to another account, that this person, you don't know where this person works or where the other one works. You look at the contract and the contract has a whole number, and my learned friend talk about the vast number of companies. What does that have to do with Mr. Williams and LCW? Mr. Williams' evidence is consistent. He understood this transaction. He was not misled by this transaction. He felt that he was being misrepresented on the question of what type of title he would get, corporate, the shares, or the land title. But other than that, you will read email after email after email of him saying, please, I want my property, I want my property, I want my property. My point, Your Honors, it is a legal construct to say that there are a vast number of companies, there are employees, you're signing that you're a director of different companies and all of that. All of that was entirely irrelevant to LCW, entirely irrelevant. He rescinded because they did not deliver. I repeat, This claim was alleging fraudulent misrepresentation. It was rejected. It was alleging breach of trust. It was rejected. The only liability arises on the basis of breach of contract. Your Honor, much has been said about paragraph 35, and I respectfully disagree with my learned friend that the last sentence of paragraph 35 creates a wider category. My respectful submission, and I don't know whether you want me to read the whole paragraph now, but the last two sentences, but the recognition of a small residual category of cases where the abuse of the corporate field to evade or frustrate the law can be addressed only by disregarding the legal personality is, I believe, consistent with authority. That is the result of Justice Sumption touring through the cases and coming and saying it is hardly ever applied, it is hardly ever exists. There is a very small residual number of cases where it actually is properly used. He was not saying there's an evasion principle, there's a concealment principle, and then there's another category. That is not what paragraph 35 is saying. I leave it to the court to read it.
Mr. Courtney, on that, I'm interested in that submission. Do I understand you to be saying that Lord Sumption, after the touring of the case law, you said, brought it down to that? Is that your submission?
That is my submission.
Okay,
sorry.
But then he does present two principles, the principle of concealment and the principle of evasion. At paragraph 28, I mean, that's where that thesis begins. Help me understand this. I think it begins with saying, well, the principle of concealment is not about lifting corporate veil at all. It is a banal concept. All it does is to identify who the real actors are. Is that correct?
That is correct, Your Honor.
Now, if that is Mr. Marshall says it's all up with semantics, says whether you call it concealment or you call it evasion, it all boils down to the same thing. Now, back to that principle of concealment, is it really all about identifying the real actors? If you, after you've identified the real actors, you stop there and say, well, Clement, that's it, go home. Or is there something else that must be done after you have identified the real actor? If that's something else that must be done, is we have identified the real actor, and that is what the exercise is all about, then we're going to impose a remedy. What would that remedy be for and why? Would it be about evasion of legal obligation or frustration of the law?
Your Honor, you asked multiple questions in that, what appears to be one. Let me try to respond. First of all, the reason in my respectful submission, Justice Sumption says that the concealment principle is not a lifting of the corporate veil or the piercing of the corporate veil, is because what you have in that scenario is a situation, again, like in Guilford, where someone is using the corporate separate legal personality, to hide, for example, Press itself. In Press, the companies, the Press Group, the Petrodale group of companies, were owned by other companies, but everyone knew who was behind those other companies. So on paper, when you look at the group, you would believe that it's just a company, another company that owns the Petrodale group. In fact, Mr. Press was hiding behind those companies in order to, and it did not in this particular case, but in order to establish liability of the companies, you just look behind the veil and you say, listen, even though you have separate legal personality, for all intents and purposes, this is you. You ask the question.
Is that the end? Would that be the end of
No,
concealment,
that's what
or
I
do
was
you do
about,
something else?
I was about to say. You ask the
All right.
question, is that the end of the road? And it is not the end of the road. It is not the end of the road, because if you answer that question affirmatively, you then impose liability on the company, not the controller. You impose liability on the company because we are, quote unquote, lifting the veil. We are not recognizing the separate legal personality of this company, because when I look behind the veil, I see you as the actor who is guilty, on my case, on my submission, of some attempt to evade or to avoid some, frustrate some law or some obligation. So it is not the end. You then impose liability on the company for the attempt to use the corporate separate legal personality to avoid or to evade.
I'm not clear with you there. I'm not following you. You have a scenario where you are seeing a company, but you want to go. You want to, well, it looks to me that there's something more to the story here than the company. We want to see who it is that's behind this company. And you go see that person, you do stuff, lift the veil, or whatever it is you need to do, and you find that person. And you're telling me after you've done that, you turn around and lift and impose liability on the company you already saw.
Yes, Your Honor, yes.
Okay.
The reason being that, and this is the analysis of law justice assumption. If A is under a liability, take Guilford, he is under a liability of a restrictive covenant. In order to evade that obligation, he forms a company. He operates that company to do exactly what he was doing before, the leather company. Exact work that he was doing. So, in effect, he is using the separate legal personality to give the impression that he is not involved. He is concealing his role. And what, in those circumstances, the submission is that he is under that obligation. You look at that company, you look behind the veil, you see him doing the wrong that he was precluded from doing, and you say to the company, I will impose that liability on you, on the company. So that is my understanding of the concealment principle. And Your Honor, just to be clear, you're right. When you start at paragraph 28, coming right through to 35, and I urge the court to look at the last sentence of 35, you will see the same language that law justice assumption is using throughout, evasion, etc., etc. So he's recognizing that there's just, this is a remedy of last resort, and really it's raised, but it is very rarely applicable to factual circumstances. Your Honor, a couple other points.
Yes, because we are running out of time, Mr.
I'm fully aware. I'll be two minutes.
Sure.
My learned friend said, in answer to Mr. Justice Jamadar, that the core of this problem is the co-mingling of funds. I repeat to this court, Mr. Justice Balkan, in pellucid language, said there has been no misapplication, there has been no misappropriation of the funds. That is what he said. And the same submission about commingling was made to the courts below. LCW has not appealed that finding. It is difficult to understand how one can make an argument that there is improper dealing with the funds when the decision which we are appealing specifically says it was not misapplied and it was not misappropriated.
But for the record, what paragraph of Mr. Justice of Appeal Balkan's judgment?
Page 35, paragraph 84. And the last point, Your Honor, that I would, and I really don't know how to respond to it. This whole notion of undercapitalization. I don't know where, I don't know what my learned friend was referring to. Let me just leave it at that. I cannot respond to it because I don't know what learning he was referring to. And actually, for completeness, just I feel obliged to mention this. Again, it was said that I was misrepresenting to the court. There was no misrepresentation. What I said, and indeed Justice Barrow raised it from the very beginning, that there was an attempt to resolve this issue by selling the property or giving it to him, he rejected it, or selling the property. That is acknowledged in the evidence of Mr. Williams. I did not say, I repeat, as my learned friend said I did not say that the proposal was to transfer the shares to them and that is what I am continuing to argue for. I brought that up merely to say, which is a fact, that Mr. Williams signed those share transfers, and I said it supports my argument that his intention was to proceed with this transaction, but for the delay. I believe I was very clear in answer to Mr. Justice Jamalar about it was my client who obviously avoided it. Your Honor, I will
Mr.
rest
Courtney,
there.
no, before you go, what's the applicable law? You've forgotten me.
My apologies. I agree with my learned friend on that aspect, that the applicable law would be Belize, and that on the private international law principles, if you went to those jurisdictions, you would still find a separate legal personality. The contract was to be performed in Belize. It's written and saying that the law is applicable, is the law of Belize. So I think the primary law to apply is the law of Belize.
And we were dealing with land in Belize, which has to be governed by Belize law, whatever the nationality of the various entities may be.
Guided, Your Honor. Most obliged, Your Honors.
Thank you so much, Counsel. Thank you to both of you. And we will reserve our judgment in this matter, Counsel, and we'll certainly get back to you in due course. Madam Deputy Registrar, you may close the matter.
Thank you so
Thank you,
much.
Your Honor.
Thank you so much, Madam Justice Rajnatli. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Jamada. Thank you, Madam Justice Ononewu. And thank you, Mr. Justice Ibu Suji. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you very much.